Hello everyone, my name is Stephen Lloyd. I'm here today in my capacity as convener of the Public Law section of the New South Wales Bar. I'd like first of all to acknowledge the Gadigal of the Eora Nation and the traditional custodians of the land upon this court is built, and pay my respects to their elders both past and present. Today we have the 8th Spigelman Oration. These presentations are made in honour of the Honourable Justice James Spigelman, ACQC, and in particular his profound contributions to the area of public law that he made as a practitioner, as a jurist, and as a public thinker. My role today is to welcome and introduce our presenter, who will speak on the topic of implications. Our speaker tonight is, of course, the Honourable Justice James Edelman, who is very well known to everyone as a Justice of the High Court of Australia. His honours, professional and academic achievements are so extensive I could spend most of the time this evening recounting them. I won't do that. I will, however, say that he was educated at Scotch College in Perth before doing bachelor's degrees in economics and law at the University of Western Australia. Apparently that was insufficiently challenging, so while he completed those degrees, he also undertook another bachelor's degree in commerce at a different university, Murdoch University. After spending time as the associate to the Honourable Justice Toohey of the High Court, Justice Edelman was awarded a Rhodes Scholarship in 1998. He completed his doctorate at Oxford in 2001, whereupon he commenced practice at the bar in Western Australia. His Honour practiced as a barrister over the next 10 years in WA and then later at One Essex Court in London. To fill in his free time, he took a teaching position at Keble College in Oxford in 2005 before being awarded the chair of the Law of Obligations at that college in 2008. Amidst what I can only assume were the not insignificant demands of practicing at the bar in 2 jurisdictions and being a professor at Oxford, His Honour found time to write or edit 6 books on the topics of damages, unjust enrichment, and restitution, and others. That was all before His Honour took a judicial appointment in 2011 to the Supreme Court of Western Australia, by which time His Honour had published more than 80 articles, notes and reviews on a vast range of legal topics. Notwithstanding His Honour's appointment to the Western Australian bench, His Honour also continued to teach as an adjunct professor at the University of Queensland and a conjoint professor at the University of New South Wales. In April 2015, His Honour was appointed to be a Justice of the Federal Court of Australia based in Brisbane. And around a year and a half later, His Honour was appointed to his present position in the High Court of Australia. His rate of publications has not noticeably diminished in the time since he took his judicial appointments. I want to thank him on behalf of the New South Wales Bar Association for agreeing to give this presentation. I have only to call upon the seemingly inexhaustible Justice Edelman to present the 8th Spigelman Oration.
Thank you very much, Stephen. May I also commence with what is on the 30th anniversary of the Mabo decision, much more than just a conventional platitude, but a truly respectful acknowledgement of the deep bond that's felt by the traditional custodians of this land, the Gadigal people of the Eora Nation, and I too pay my respects to them and to their elders, past, present and emerging. Can I say what a pleasure it is to be invited to deliver this oration in honour of one of New South Wales's most distinguished jurists. And I've chosen a topic to speak on, which is one upon which he has written in such learned terms. And I want to offer a few thoughts about the nature and development of rules relating to implications. There's an old joke that's told about a professor of physics who'd cautioned his students against undertaking a particular practical experiment. But, objected the students, the experiment seems to work in practice. Maybe so, replies the professor, but does it work in theory? In ordinary conversation and in everyday life, our principles of the interpretation of the meaning of language are much like this. They work well in practice, even if there's little understanding of them in theory. So too in the interpretation of legal instruments. But at the margins, where the issues are highly contested and contestable, it's important for lawyers and judges who seek to provide the best possible interpretation to understand the theory of what our language is doing. So the purpose of this presentation and developing the work of the Honourable James Spigelman is unashamedly an exploration of the theory of one of the most important aspects of the principles of legal interpretation, namely implications. Can I commence then with a neoclassical source of deep learning?
Dad, Mom's spending more time at Moe's than you are.
And they seem awfully chummy.
Just what are you inferring?
I'm not inferring anything. You infer, I imply.
This exchange from The Simpsons neatly illustrates a point that was made by the United States philosopher of language Professor Horn, that speakers implicate, but hearers infer. The implication contained in and intended by the words of Lisa was that Marge was having an extramarital affair. If Homer had thought about this, he would have drawn this inference from her statement. In broad terms, Lisa was implying, and Homer would have been inferring. In everyday life, we interpret the meaning of sentences that we hear or read by a process that involves two concurrent but interrelated and simultaneous elements. We consider the semantic meaning of the words, and we draw inferences from the words that rely upon their context and the purpose for which they are uttered. The process of drawing inferences that enriches the semantic meaning is called pragmatics. And every meaningful sentence involves pragmatics and requires some inferences to be drawn. It's no coincidence that lawyers use the same techniques of ordinary language to interpret written instruments, including the Constitution, but also statutes, contracts, wills, and trusts. The basic techniques for the interpretation of legal instruments are our tools of language. They're not secret spells that are possessed only by lawyers. If these techniques were unique to lawyers, we could not morally justify compelling the public to follow written rules which they did not have the skills to interpret. Nor would it make sense for laws to be enacted by a parliament composed of members, many of whom are not lawyers. In this presentation, I will explain how an understanding of the different types of implication and the inferences that we draw as readers can permit us to understand the basic operation of the legal rules concerning implications. The presentation will be divided into three parts. The first part will explain the nature of an implication and the spectrum of different possible implications that can exist. The key point that I'll make will be that there's a spectrum of implications which range from those where very little pragmatic input needs to be added to the semantic content of the words, to those where substantial pragmatic input needs to be added. The second part explains three key principles to understand in drawing inferences that recognise implications. The three principles are as follows. One, that the meaning of words in law as in life depends upon what the speaker or the writer of the words is understood to intend by the use of the words. Where there's no actual person who's speaking, we understand meaning by reference to the intention of a notional person, so a parliament, or a reasonable person in the position of the contracting parties, or a reasonable settlor and trustee, and so on. Two, with limited exceptions, when we interpret the meaning of a legal provision, just as when we interpret the meaning of a sentence in ordinary life, the semantic or literal meaning of the words is considered at the same time as the pragmatic inputs as context and purpose. Three, and perhaps the largest point that I'll make in this presentation, the further that a proposed implication is along a spectrum, which ranges from little pragmatic input to the most pragmatic input, the more necessary the implication must be in order for it to be recognised. The final part of this presentation then turns to a controversial example in constitutional law of the application of these building blocks of the philosophy of language. And the example is the implied freedom of political communication. So can I begin in part one with the error that was made by Homer Simpson in describing the speaker's process of implying as one of inferring? Instead of mistakenly using infer for imply, lawyers and judges frequently make the opposite mistake and use the language of imply when they mean infer. As Brian Garner has observed, through the process of hyperlage, lawyers have come to use the word imply by reference to what judges do as opposed to the circumstances by which meaning is included in what is expressed. Common examples of this confusion are lawyers and judges who speak of whether an implication can be made from a statute or whether a term can be implied into a contract. This error of language arises because the implication is already there. It's identified by inference. In the High Court of Australia, the same point was made by Justice Isaacs, who said that an implication is something that the speaker or writer should be understood to have meant by what is actually said, although not stated in express terms. Nevertheless, Justice Isaacs said that the implication is still included in what is expressed, or perhaps more precisely, as the Oxford English Dictionary defines the adjective implied, an implication is involved in what is expressed. Hence, as Justice Windeyer said of implications, our avowed task is simply the revealing or uncovering of implications that are already there. There are, however, difficult questions concerning what is meant by an implication being already there. The philosopher of language, H.P. Grice, drew a distinction between what is said and what is implicated. Grice's notion of what is said is essentially the semantics of the sentence, which Grice described as the conventional meaning of the sentence. Everything else, he said, was an implicature. Grice saw what is said as the literal, context-free meaning of the sentence. Everything else, he said, was implied, suggested, meant. The process of identifying everything else, he accepted, depends upon pragmatics, that is, context and purpose. Although Grice prompted one of the largest revolutions in linguistics in the latter part of the 20th century, his distinction between what is said and what is implicated has been controversial. The meaning of what is said in a sentence, that is in a sentence rather than a single word, will rarely be only conventional. Pragmatics, that is, context and purpose, are everywhere in language. There's an old joke that epitomizes the importance of pragmatics in interpretation. On the eve of retirement, a judge is asked whether there's anything that they regret over a long career in the judiciary. The judge pauses for a long time and then replies, dwelling on the semantics at the expense of the pragmatics. The interviewer looks puzzled and asks, could you explain what you mean? The judge replies, yes, I could explain. The point of the joke is that only the slightest pragmatic input was needed for the interviewer's question to be understood as asking the judge if they would explain what was meant. Implications are best understood as falling on a spectrum. At the one end of the spectrum, an implication like that involved in the interviewer's question requires very little pragmatic input. Only little pragmatic input needs to be added to the semantic meaning of the words. At the other end of the spectrum, the pragmatics of context and purpose do almost all of the work in providing the implication. The key point in the first part of this presentation is explaining this spectrum in the coherent language of relevance theory, that is, the language of explicatures, implicatures, and presuppositions. The language of relevance theory helps us to understand what we are doing with the concepts and the spectrum of implications that contains, usually at one end, explicatures, where the implication is most heavily based on the text, and as one moves toward the other end of the spectrum, the explicatures fade into implicatures, where the implication is less heavily based on the text and relies more on the pragmatics of context and purpose. Two of the strongest proponents of relevance theory, Sperber and Wilson, have observed that an explicature is a combination of linguistically encoded and contextually inferred conceptual features. The smaller the relative contribution of the contextual features, the more explicit the explicature will be, and inversely. So to start then with explicatures. The relevance theorists in the philosophy of language have described explicatures, as I've said, as explicating meaning directly from the words of an instrument. It's an inference from the linguistically provided template. The primary focus of legal interpretation commonly involves these inferences that are drawn out from the words. But the technique on relying upon these explicatures is unfortunately rarely acknowledged in judicial decisions as involving the recognition of an implication. It's just seen as ordinary interpretation, without noticing that inferences are involved and that implications are being recognised. But express terms will almost always require something additional in order to give them their intended meaning. That addition comes from the pragmatics of context and purpose. The pragmatic inference might be no more than the correct semantic or literal meaning of the words in cases where there are a number of possible different meanings. But the pragmatic inference might have the effect that the words bear a different or even completely opposite meaning from their semantic meaning. Or the pragmatic inference might be that the correct level of generality for the meaning of the words is set at a different level. In each case, the pragmatic inference draws the meaning outwards from the words. It explicates. An example from everyday life is a notice in the Chancery Lane Underground station that is said to say that dogs must be carried on the escalator. It was joked among Chancery lawyers that the semantic common lawyers would often sit and wait for hours for someone to supply a dog in order for the lawyer to be able to get on the escalator. The common lawyers' response to that joke was that the Chancery lawyers would wait even longer because they would understand the sign to mean that there must be at least 2 dogs, plural, carried in order to get on the escalator. The same use of pragmatics in explicatures is necessary in legal interpretation. An example is Section 34 of the Constitution. Section 34 provides for the qualification of members of the House of Representatives and states that, until the Commonwealth Parliament otherwise provides, he must be of the full age of 21 years. Section 48 refers to an allowance that each senator and each member of the House of Representatives shall receive on the day on which he takes his seat. Similarly, the Governor-General is described with the pronoun he in sections 5, 58, 126. Senators are described with the pronoun he in sections 15, 46 and 48. Ministers of State are described with the pronoun he in 64. And Justices of the High Court are described with the pronoun he in section 72. Even the rights of residents in states are referred to by reference to a resident with the pronoun he in section 117. But on no reasonable view of the intended meaning of these provisions would the use of he be understood to mean only a man. In 1901, section 23 small a of the Acts Interpretation Act had provided that unless the contrary intention appears, words importing the masculine gender shall include females. The inclusion of people other than men in the meaning of the word he arises by pragmatics, with the drawing of an inference to recognise an explicature in the following way. The pronoun he must be given a meaning at the intended level of generality. He could have several levels of generality of meaning. In some contexts, it could mean a male human. In other contexts, it might be used more generally to mean any human. More generally still, it might be used to mean any animal, human or otherwise. I venture to suggest that the essential intended meaning in the Constitution was any human. It wasn't intended to apply at the lowest level of generality to confine the operation of each of these provisions to male humans, nor was it intended, in its essence, at the broadest level of generality to permit, for example, a member of Parliament to be a fish, or perhaps less facetiously, it couldn't be said that an intelligent chimpanzee could be a resident of a state for the purposes of section 117. I move then from explicatures to implicatures. While explicatures use pragmatics in a limited way to draw meaning out from the words, an explicature will shade into an implicature as the exercise moves from being less of an exercise in ascertaining the meaning of express words to being more of an exercise in ascertaining by inference the additional words that are implied in the provision. An example of that is the decision in Burns and Corbett. Sometimes it's clear that an implication must exist, but it's unclear what the implicature is. The case of Burns and Corbett concerns state legislation in New South Wales, which had conferred jurisdiction on the Civil and Administrative Tribunal of New South Wales. It was accepted that the tribunal, the New South Wales Civil and Administrative Tribunal, was a tribunal and was not a court. The state legislation establishing the tribunal included the power to decide some disputes between residents of different states. Under the Constitution, a dispute between residents of different states, which is sometimes described as diversity jurisdiction, is part of concurrent state jurisdiction and federal jurisdiction. The question in Burns and Corbett was whether the constitutional provisions contained an implication that only state courts could exercise that state jurisdiction and not state tribunals. The constitutional provisions said to contain this implication were provisions that empowered the Commonwealth Parliament to invest federal diversity jurisdiction in any court of a state. That's in section 77.3, and in section 77.2 to define the extent to which the federal diversity jurisdiction of a federal court shall be exclusive of that in the courts of the states. At the time of federation, a diversity matter was a matter that belonged to the courts and tribunals of the states. There were numerous tribunals which would not today be regarded as courts that decided such disputes alongside the courts. There would be no point in section 77.2 giving a power to the Commonwealth Parliament to make the diversity jurisdiction of the federal courts exclusive of the state courts if it could not also be made exclusive of the state tribunals. There were, however, three possible implications that could give effect to the purpose of section 77.2. One would be an explicature, for which no counsel argued. Two are implicatures. The explicature, which, as I said, wasn't argued, but would have met a number of difficulties, would have been to treat the words courts of the states as though they included a tribunal of the state. As Justice Isaacs said a century ago, a court is some organ constituted by the state to exercise judicially some portion of the king's judicial power. Insofar as a state tribunal exercised judicial power, on that view, and as I say, not without considerable difficulties, it would be a court, and the federal judicial power could be made exclusive in the diversity matters for a federal court. Putting that approach to one side, there were two possible implicatures that could give effect to the purpose of section 77.2. The majority effectively held that there was an implicature to the effect in italics, that jurisdiction over those subjects could only belong to or be invested in courts and not in tribunals of the states. This implicature had the strength of drawing not merely from section 77.2 but also from section 77.3. By contrast, the minority effectively held that there was an implicature which focused upon section 77.2 that treated the power as one which was invested in courts or tribunals of the states. I was a member of the minority. In my view, the difficulty with the implicature accepted by the majority, although it was based upon a number of the different provisions, was that there was no intention prior to or at federation to abolish the existing state diversity jurisdiction, or in relation to another matter within 77.2, admiralty or maritime jurisdiction. The question would be, ultimately, whether or not the tectonic plates at federation had sufficiently shifted so that jurisdiction over diversity, admiralty, maritime matters exercised by customs commissioners, land boards, marine boards, or railway commissioners had been changed and altered so that the proper implicature would be one so that those subjects were confined to courts and not tribunals of the states. The other type of implication that's brought out in the philosophy of language is presuppositions. Presuppositions are a type of implication that span across both explicatures and implicatures. Like explicatures, some presuppositions are heavily dependent upon the semantic content of a sentence or provision. For example, the King of France is bald presupposes from the semantic content of the sentence that there is a King of France. The minister is to consider a valid application for a visa presupposes from the semantic content of the provision that there is a minister responsible for the administration of the Migration Act. Presuppositions in life, as in law, are endemic. As Professor Pinker has observed, language itself could not function if it did not sit atop a vast infrastructure of tacit knowledge about the world. John Searles rightly pointed out that for a large number of cases, the notion of the literal meaning of a sentence only has application relative to a set of background assumptions. And furthermore, these background assumptions are not all and could not all be realised in the semantic structure of a sentence, the way that presuppositions are. These presuppositions and the nature of background assumptions are much less dependent upon the semantic content of the sentence and rely much more on the pragmatics of context and purpose. So in law, a famous example of the presupposition is that enunciated in Marbury and Madison, that it's for the courts rather than for Parliament to invalidate laws which exceed the limits of legislative power. That principle was described by Justice Fulliger as axiomatic. The prolific nature of presuppositions can be illustrated with a fictional anecdote. A professor of linguistics is on a train giving a tutorial to one of his students. As the train passes through the countryside, the linguist points to the sheep in the paddock and directs the students to say something about the sheep, but without any presuppositions. "Look at the sheep in the paddock," says the hapless student. "You can do better than that," says the tutor. Look at the things in the paddock that look like sheep," replies the student. "Try again," says the tutor. "Look at the things in what looks like a paddock that look like they have white wool on them," says the student. "You can still do better," says the tutor. The student pauses and tries one more time. "Look at the things in what looks like a paddock that look like they have white wool on them on at least one side." As in language generally, presuppositions in legislation are common. Historically, the common law supplied many presuppositions in the nature of background assumptions. Sir Edward Coke wrote that the surest construction of a statute is by the rule and reason of the common law. That reason of the common law was the foundation for the celebrated decision of Justice Byles in Cooper and Wandsworth, where His Honour said of the rules of procedural fairness that although there are no positive words in a statute requiring that a party shall be heard, yet the justice of the common law will supply the omission of the legislature. As Justice Brennan said in FAI Insurance Limited, the justice of the common law is the matrix of legislation, and where the legislation is silent as to the conditions governing the statutory power, it may be inferred that the legislature intended that the justice of the common law should supply those rules of procedural fairness. A further example is the inference that the conferral of a statutory power requires the power to be exercised reasonably. In Plaintiff M1 2021, 4 members of the High Court explained in the context of a duty upon the minister to engage with representations made by an applicant that it was well established that the requisite level of engagement by the decision maker with the representations must occur within the boundaries of rationality and reasonableness. What is reasonable is determined by ordinary conventions as shaped by the legislation. Moving then from the civil law to the criminal law, a presupposition in the criminal law is that statutory offence will only be taken to be proved if the trier of fact is satisfied of guilt beyond reasonable doubt. As Justice Kirby said in Crown and Tang, in dissent, but not on this point, it would require very clear statutory language to render the mere performance of an act criminally blameworthy without regard to being had to the golden thread that's proof of guilt beyond reasonable doubt. Another presupposition, which has been recognised for hundreds of years as, I quote, a fundamental principle for which no authorities need to be cited, is that guilt for an offence usually requires a criminal mind, such as knowledge or intention. That's again been described as a common law presumption. The presupposition operates as an implicature that involving an inference of words such as with intention or with knowledge. Hence, in Sweet and Parsley, Lord Reid described the implication as one that's recognised by reading in words, by which he meant inferring that words had been intended. He said there's for centuries been a presumption that Parliament did not intend to make criminals of persons who were in no way blameworthy for what they did. The importance of these presumptions is sometimes overlooked. A recent appeal to the High Court of Australia in Bellin, Tasmania concerns Section 14 of the Misuse of Drugs Act. That section provided that a person must not supply a controlled drug to a child. There was a separate offence in Section 26 for supplying a controlled drug. As Justice Gleeson and I observed, counsel for the appellant had repeatedly disclaimed any submission that Section 14 contained any mental element, relying only upon a submission that criminal conduct had been excused. It might be thought surprising that Parliament would have taken to have intended that a person had committed the offence of supplying drugs to a child if the person did not have sufficient knowledge that what was supplied was drugs or did not have sufficient knowledge that the person was a child. If neither were required, then subject to excuses, a person could be criminally liable for the offence of supplying drugs to a child if the person did so honestly and reasonably believing they were supplying food to an adult. I turn then to the part 2 of the presentation, which is concerned with the basic principles in law as in language for recognising implications. Whether an implication is an explicature or an implicature there are three basic principles involved in drawing pragmatic inferences that identify the implications. The first is that our concern with the meaning of any legal provision is a concern with what philosophers of language call speaker meaning. Although in law, the speaker is usually a notional person, such as a reasonable person in the position of the parties to a contract, a reasonable settlor of the trust, or a reasonable parliament. In this respect, the approach to meaning is not fundamentally different from any everyday use of language. The basic meaning of written legal instruments, such as statutes or the Constitution, can therefore be understood by any person, lawyer or not, using their ordinary conventions of language. If legal instruments were not able to be so understood, there'd be a serious threat to those aspects of the rule of law that are concerned with clarity, intelligibility, and accessibility. Moreover, institutional problems would arise for the many members of Parliament not possessing legal qualifications if the words of bills upon which they voted were not to be understood according to the ordinary conventions of language. Secondly, the comprehension of language functions at the level of the sentence, not the single word. Although the meaning of words is important, the ultimate search for speaker's meaning is the speaker's meaning of sentences in legal provisions. The meaning of a sentence, in law as in language, requires consideration of the semantic or literal content of the words at the same time as considering their pragmatic content. That is, the context and the purpose of the words. It is emphatically not a two-step process of identifying a range of possible semantic meanings and then choosing the best of those meanings. In this respect, the fashionable expression constructional choice can sometimes be misleading. Thirdly, the extent to which it's necessary to draw an inference will usually depend upon the extent to which semantic content of a provision contributes to the inference. This is particularly so in instruments like legislation or professionally drafted contracts, where it should be harder to recognise an implicature that draws little from the written words than an explicature that draws substantially from the written words. I want to deal with each of these 3 points in turn. So first, the notion that the meaning is what is intended by the speaker or writer. There are two approaches that compete for acceptance in the field of interpretation. The first is that the meaning of a sentence in an instrument is interpreted by the reference to the meaning that the listener expects or the reader expects to have been intended by the speaker or the notional speaker. We can call this expected speaker meaning. The second is that the meaning of a sentence is interpreted autonomously from anything that a speaker or notional speaker might be thought to have intended. This might be described as autonomous meaning. In everyday life, we're almost always concerned with expected speaker meaning. So the words, "if you want to stay healthy, get out of Brisbane," will probably mean something entirely different if spoken by a doctor to a patient with heat-induced asthma than if spoken by a crime boss to a rival. By having regard to each of context and purpose, the pragmatics of the sentence, one interpretation will be objectively better than the other. The context and purpose reveal the best fit with the speaker's intention. On the other hand, a scholar who is interpreting a poem will be concerned with autonomous meaning. With autonomous meaning, the interpretive process is essentially creative. Whether one interpretation is better than another will be, generally, a matter of subjective preference. For centuries, judges have interpreted legal instruments by reference to speaker meaning. In a famous passage on statutory interpretation, quoted by Theodore Sedgwick, Francis Lieber wrote that a sentence can only have one true meaning, and words must therefore be taken as the utterer probably intended them to be taken. Where the legal instrument is a statute, the utterer is the construct or the notion of the Parliament. As Dr. Eakins and Professor Goldsworthy have traced, this notion of speaker meaning derives at least from the 15th century, with adherents from Plowden, Selden, Cook, Bacon, Blackstone and Dwaris. At Federation, this notion was unchallenged. As Chief Justice Griffith had emphasised in a quotation from the Sussex peerage case, to which he would return again and again and again in the early years of the High Court, the only rule for the construction of Acts of Parliament is they should be construed according to the intent of the Parliament that passed the Act. Further, the same rules of interpretation apply to the Constitution as apply to any other written document, as he had said. That approach to speaker meaning justifies the insistence by courts that there is only one right answer or one correct meaning in the interpretation of legal instruments. But there is a competing view which suggests that the words of legal instruments have an autonomous meaning. The most powerful recent defence of that approach is that of Lord Burrows. In the Hamlin Lectures, argued in his inimitably brilliant style, Lord Burroughs said that although statutory interpretation is constrained by the words, context, and purpose of the statute, the task of deciding on the best interpretation of the statute, with the benefit of hindsight, falls to the judges, and it is in this sense somewhat analogous to their role in interpreting a common law precedent. There are 4 fundamental difficulties, I would suggest, with an approach which treats provisions in statutes or other legal instruments as having an autonomous meaning independently of any search for notional intention. First, if we really believed that a provision had an autonomous meaning, then it would make no sense to insist upon consideration of context or purpose at all. An attempt to interpret the meaning of a poem need not be governed by a poet's purpose in writing or the context in which they wrote it. But we insist upon legislation being interpreted by reference to Parliament's purpose and the context of the legislation. That can only be explicable if we are concerned with Parliament's notional intention. Secondly, the notion that words of a statutory provision have a range of possible meanings from which a judge can choose is in tension with the rule of law value that the meaning of legislation should be accessible and able to be understood by the public generally. The manner which the public understands and interprets written laws is by the ordinary tools of language, which, as I've explained, involve discerning meaning by drawing inferences about the intention of the speaker. Without those tools, the public would have no way of accessing or unlocking or understanding the meaning of legislative provisions. Thirdly, if the governing principle were not a search for the intention of Parliament, then how could the court ever contradict the plain semantic meaning of a provision? For instance, in the case of Mondelez Australia Proprietary Limited, the High Court considered the meaning of the expression 10 days paid personal carers leave. A minority of the court held that 10 days meant 10 periods each of 24 hours. Such a literal or semantic meaning is undeniable. If meaning were autonomous, it would be impossible to contradict this conclusion. But a majority of the court, including me, held that 10 days instead meant for every year of service equivalent to the employee's ordinary hours of work in a week or over a 2-week fortnightly period, or 1/26th of the employee's ordinary hours of work in a year. I would suggest that no dictionary and no ordinary use of language would ever attribute that meaning to the expression 10 days. The majority's approach could only be justified as an application of speaker's meaning. The majority view was that the context in which the legislation was enacted was so strong that Parliament had intended only to simplify the expression of a very complex formula, but not to change the meaning of that formula. Fourthly, many of the principles by which legislation is drafted and the well-known maxims by which legislation is interpreted are conventions of language based upon speaker's meaning. These conventions of language are inseparably bound up with the intention of a speaker. For instance, when my 14-year-old daughter saw a preview for a movie that said not suitable for children 12 and under, she understood that there was no restriction upon children who were 13 years or older. No one needed to tell her she was applying a Latin maxim called expressio unius est exclusio alterius. And when I gave my son my credit card to purchase flour, milk, eggs, and butter, etc., he did not need to be able to translate Justem generis to know that the etc. did not cover a Sony PlayStation. Our legal maxims of interpretation are the ordinary conventions of language from which we use to infer intention. The second point I move to then is that there is no separation of the semantic from the pragmatic in our general rules of language or in legal interpretation. It's now well established that the process of interpretation of legal instruments is not a two-stage process of identifying first a context-free semantic meaning and then enriching that meaning with pragmatics such as context or purpose. Interpretation is a single process. In legal interpretation, as in ordinary life, the meaning of a sentence depends upon a concurrent consideration of the semantic or literal meaning of what is said and the pragmatic effect of purpose and context that supplies implications. That's why in CIC Insurance and Bankstown, 4 members of the High Court said that interpretation of meaning insists that context be considered in the first instance, and that context includes such things as the existing state of the law and the mischief which by legitimate means one may discern that the statute was intended to remedy. Nevertheless, it's not impossible for legislation expressly or impliedly to create a rule that the interpretation of the provision must ignore some pragmatics. In Westfield Management and Perpetual Trustee, the High Court held that extrinsic evidence was not admissible to establish the manifested intention of the parties to an instrument registered under the Torrens scheme of title. The reason for this exclusion was that a person inspecting the register cannot be expected, consistently with the scheme of the Torrens system, to look further for extrinsic material which might establish facts or circumstances existing at the time of the creation of the registered dealing and placing the third party in the situation of the grantee. Legislation can also go further and can even alter or amend ordinary language conventions. A controversial example of this is the decision of the Supreme Court of the United States in Bronston, United States. Mr. Bronston was a failed movie producer. His company, Samuel Bronston Productions, went bankrupt. At a bankruptcy hearing, the following exchange took place between a lawyer for one of the creditors of Bronston Productions and Mr. Bronston. The lawyer believed, correctly, that Mr. Bronston had previously had a Swiss bank account. Question: do you have any bank accounts in Swiss banks, Mr. Bronston? Bronston: no, sir. Question: have you ever? Bronston: the company had an account there for about 6 months in Zurich. Question: have any nominees who have had bank account have you any nominees who have had bank accounts in Swiss banks? No, sir. Question: have you ever? No, sir. The question for the Supreme Court was whether Mr. Bronston had committed perjury. The relevant offence in the federal statute was committed by a witness who, quote, willfully states any material matter which he does not believe to be true. Delivering the opinion of the Supreme Court, Chief Justice Berger accepted that it might be reasonable in casual conversation to interpret Mr. Bronston's answer to the question about whether he'd ever had a Swiss bank account as containing a negative implication. In other words, in casual conversation, to state any material matter would include both things that are expressly stated and things that are impliedly stated. But the Chief Justice continued, and I quote, "We are not dealing with a casual conversation, and the statute does not make it a criminal act for the witness to willfully state any material matter that implies any material matter that he does not believe to be true." In effect, the reasoning of the court was that the federal statute had altered the ordinary conventions by which language is to be understood. One of those very conventions is what Grice called the maxim of relation or relevance. Words need to be appropriate to the immediate needs of the conversation. But could the federal statute really have abolished this ordinary convention of language completely? That it could not is illustrated by one of the very examples acknowledged by the court in Bronston, which involved recognising another one of Grice's maxims, which is that of quantity. That's the maxim that the correct quantity of information will be supplied in a conversation. Suppose a person in a trial for shoplifting is asked in cross-examination, "How many times did you go to the store that day?" Suppose that the person had gone to the store 30 times in preparation or to case the place for the theft. But they'd answered that they'd been to the store 5 times. Literally, they'd be telling the truth. The person had been to the store 5 times. They'd also been there 6 times, 7 times, 8 times, and so on. The court in Bronston said that the answer 5 would be perjury. But the reason it's perjury is because the application of the conversational maxim would permit the cross-examiner to imply that the person had been at the store only 5 times from the answer. Turning from the United States to Australia, the High Court in BVD 17 and Minister for Immigration also took an approach which concluded that Division 3 of Part 7, capital A of the Migration Act had altered the ordinary conventions of language by excluding an implicature that would otherwise have arisen. The reasoning of the majority relied upon a section of the Migration Act which said that certain provisions were an exhaustive statement of the requirements of the Natural Justice Hearing Rule. In effect, their honours held that this meant that the only requirements of the Natural Justice Hearing Rule were those that were expressed, rather than those that were implied in the relevant provisions. In other words, Parliament's reference to an exhaustive statement changed our conventions of language to require the interpretation of words by reference only to express meaning and not to the particular implied meaning. The third point is that the more pragmatic input that's required, the more necessary an implication must usually be. A general principle of language is that the closer the association between a potential implication and the semantics of a sentence, the more likely it is that an implication was intended. Although an explicature, which relies heavily upon text for meaning, is rarely treated in law as an implication, this principle is true of both explicatures and implicatures. As Sperber and Wilson observe, the greater the inferential element involved, and hence the greater the indeterminacy, the weaker the explicature will be. In particular, ceteris paribus, the greater the gap between the encoded meaning of the word and the concept conveyed by the use of the word, the weaker the explicature will be. The same is true of implicatures, which usually require the court to read the provision as though it contained additional words. The greater the contribution that must be made by the missing words which are pragmatically inferred, the more unlikely it will be that the implication was intended. As Chief Justice French and Justices Crennan and Bell said in Taylor and others in Strata Plan, the question is whether the court is justified in reading a statutory provision as if it contained additional words or omitted words involves a matter of judgment and degree. That judgment is readily answered in favour of the addition or omission in the case of simple grammatical drafting errors, which, if uncorrected, would defeat the object of a provision. It's answered against a construction that fills gaps disclosed in the legislation or makes an insertion which is too big or too much at variance with the language in fact used. A substantial implication is made when what is involved requires not merely the addition of missing words, but sometimes to supply an entirely new term. Sometimes this is described as an implied term. Even though the implication might be one of an entire term, the exercise still remains one of interpretation. As Justice Mason said in Cadelpha Construction, the implication of a term in a contract is an exercise of interpretation, although not an orthodox exercise. And in Attorney General of Belize and Belize Telecom, in remarks approved by 3 members of the High Court of Australia and Commonwealth Bank of Australia in Barker, Lord Hoffman said that a court must be satisfied that an implied term is what the contract actually means. The way I put the point in Lundbeck and Sandoz was to say that it's the same process of recognising implications that's involved, whether the concern is with the meaning of the express words of a clause, or inferences that recognise additional meaning in a clause, or inferences that recognise an entire implied term. A leading case concerning the implied terms that's been referred to for a century and a half is the English decision in the Moorcock. In the Moorcock, the appellants entered into an agreement with the respondent in which the respondent agreed to pay the appellants for a right to moor a vessel at the appellant's jetty. The respondent's vessel was damaged when it was moored at the appellant's jetty due to an uneven riverbed. The appellants owned the jetty, but not the riverbed. Nevertheless, the Court of Appeal of England and Wales held there was an implied term in the contract that the jetty, and therefore the riverbed, was reasonably fit for loading and unloading. Lord Justice Bowen said that the law is raising an implication from the presumed intention of the parties with the object of giving to the transaction such efficacy as both parties must have intended that at all events it should have. As later courts have emphasised, the reference by Lord Justice Bowen to the intention of the parties was to that of a notional reasonable people in the position of the parties at the time at which they were contracting. So in Attorney General of Queensland and Attorney General of the Commonwealth, Chief Justice Griffith said that the same rule that the implied obligation or restriction set up must have been intended by the parties to the compact was a rule for necessary implication that applied to all instruments generally, including the Constitution. The point was again made more recently by the High Court in the context of rejecting the existence of a constitutional implication of freedom of movement in Gurner and Victoria. In a unanimous joint judgment, the court relied upon the leading Australian decision, Cadelpha Construction, where it was said that the court will consider what reasonable people in the contracting parties, the position of the contracting parties, would have intended to convey by the words chosen. The High Court in Gurner said that it would be, and I quote, a distinctly unsound approach to the interpretation of the constitutional text actually adopted by the framers to attribute to that text a meaning that they were evidently united in rejecting. In Cadelpha Construction, Justice Mason, with whom Justices Stephen and Wilson agreed, described 5 conditions necessary to ground the implication of a term. One of those conditions was the proposed implied term must be necessary to give effect to the business efficacy of the contract so that no term will be implied if the contract is effective without it. Similarly, in constitutional interpretation, it's commonly said that an implied term in the Constitution will be recognised only when it is necessary. In the engineer's case, for example, the joint judgment spoke of expressed or necessarily implied meaning. Professor Goldsworthy, whose thinking in this area is amongst the deepest of any Australian author, has argued that a distinction exists between implications that are based upon 2 different types of necessity. First, he says that there are legitimate implications that arise because the intention of the author or speaker is so obvious that the implication cannot reasonably be denied. In other words, the implication is so clear that it must necessarily have been intended. Second, there are what he calls dubious implications, arising because it is, in the words of Chief Justice Mason, logically or practically necessary for the preservation of the integrity of some constitutional structure, or in the words of Justice Dixon, an implication based upon what the efficacy of the system logically demands. With great respect, these two types of necessity are not distinct. The latter is no more than an indication of the former. In other words, the more logically or practically necessary a term is considered to be for the preservation of the integrity of the constitutional structure, the more obvious it becomes that such a term should be treated as having been intended by the notional body enacting the instrument. In any event, it may be that there is difficulty with the language of necessity when describing requirements for the implication of terms. If necessity were really used in its ordinary dictionary sense of inevitable, indispensable, unavoidable, such that the instrument could not possibly operate without it, most constitutional implications would never be made. In a written constitution which was intended to be sufficiently flexible to apply for hundreds of years, the notional enactors could not be taken to have intended such a limited literal approach. A better approach, at least in the constitutional context, might be to see the references to necessity in relation to implication of terms in the same way as necessity is used in proportionality testing, perhaps as an oxymoron of reasonable necessity, rather than one that insists upon actual impossibility or unworkability without the implication. Again, the larger the implication that's sought to be made, and the further the implication departs from the semantic text of the instrument, the more reasonably necessary, in the sense of the more obviously intended, must be the existence of the term. I turn then to the final part of the presentation, which is concerned with constitutional explicatures and implicatures. In remarks repeated in the High Court on numerous occasions, Chief Justice Griffiths said that the same rules of interpretation apply to the Constitution that apply to any other written document. The point that the Chief Justice was making is that the same rules and conventions of language apply to the interpretation of the Constitution as they do to the interpretation of any other legal instrument. Nevertheless, the nature of the instrument, being a constitution that was intended to endure, is a very relevant matter of context that can make an implication more reasonably necessary than, for example, a tax statute that's frequently amended. Much, however, may depend upon where on the spectrum the implication falls between explicature and implicature. The stronger the textual basis for an explicature will often have the effect of excluding any implicature of the same or similar effect, but not always. An example of an exception is the freedom of political communication that's implied by the Constitution. Sections 7 and 24 of the Constitution provide, respectively, that members of the Senate and House of Representatives shall be directly chosen by the people of the state and the Commonwealth. One explicature that arises from directly chosen by the people is that there are limits to the extent to which Parliament can disenfranchise any group of adult citizens. Another explicature arising from those provisions, as set out in Australian Capital Television and the Commonwealth by Justice Dawson, is that a choice must mean a true choice, requiring at least at the time of an election an opportunity to gain an appreciation of the available alternatives. Thus, there are limits to the extent to which a Parliament can impair, at least at the time of an election, the ability for an elector to make an informed choice. An explicature of a similar nature arises also in section 128, which provides for altering the Constitution where the proposed law shall be submitted in each state and territory to electors qualified to vote for election of members of the House of Representatives. The requirement that the proposed law be submitted to the electors includes the explicature that those electors have access to information that might be relevant to the vote they cast in the referendum. A further explicature arises from provisions such as sections 62 and 64, which require the establishment of a federal executive council to advise the Governor-General and the Government of the Commonwealth and the administration of such departments of state of the Commonwealth as the Governor-General and Council may establish. The effective operation of a federal executive council and departments of state requires information to be able to be communicated between the electors and their representatives concerning the conduct of the executive branch of government throughout the life of a federal parliament. A question then is whether beyond these explicatures implied by the text, there are any further implicatures. One suggestion was made by Justice Murphy, who concluded there was a very large constitutional implicature of a general freedom of movement and communication. In Buck and Bavone, Justice Murphy said that the liberty of persons to move freely across state borders was an almost absolute liberty, deriving not from Section 92 of the Constitution, but from the union of people in an indissoluble commonwealth. That notion soon developed to his view that in elections to federal parliament, and also in between elections, the system of representative government required a nearly absolute freedom of movement, speech, and other communication, not only between the states, but also in and between every part of the Commonwealth. Later, he added that these implicatures also arose from the nature of Australian society as democratic and as a union of free people. These broad implicatures of freedom of movement and freedom of communication that Justice Murphy had inferred have never been accepted by a majority of the High Court. The existence of a general constitutional implication of freedom of communication was rejected in Miller and TCN Channel 9. In that case, Justice Mason said he could not find any basis for implying, by which he meant inferring, a new Section 92A into the Constitution. That pithy statement was repeated in Gurner and Victoria, where the High Court in a unanimous judgment rejected the existence of a constitutional implication of freedom of movement. However, a more confined implicature of freedom of political communication was recognised by the whole of the court in Longy and Australian Broadcasting Corporation. The core of the reasoning of the court in Longy was that explicatures in provisions such as Sections 7, 24, 128, 62 and 64, which I've discussed, combined together to reflect a constitutional implicature as a presupposition, which constrained the legislature from imposing a disproportionate burden upon freedom of communication. The recognition of this implication has not been uncontroversial in either its existence or its method of application. But ultimately, like many implicatures, it involves a judgment call. Here, the judgment call concerns a constitutional presupposition, with evidence of this intention being the various explicatures to related effect in provisions such as Sections 7, 24, 128, 62 and 64. Perhaps the most sustained criticism of the existence of the implicature was made by Justice Callanan in Australian Broadcasting Corporation and Leaner Game Meats. One aspect of his reasoning was that, and I quote, even if implications may be inferred from the Constitution, the occasions for doing so could only be ones of greatest necessity. As His Honour noted, a similar form of reasoning might be taken from the statements in the engineer's case, where 4 members of the court appeared to suggest that the text of the Constitution should be interpreted without any implications arising from matters outside the Constitution. The essential lesson of this evening, I hope, is to the opposite effect. Let me explain why, in brief conclusion, by summarising the points that I've made this evening. Although reasonable minds might differ as to the content of implications, in law, as in life, implications are everywhere. Sometimes the implication might be a small explicature from the words of a legal instrument. Sometimes the implication might be a large implicature in the instrument. In every case, the implication is recognised by an inference drawn by the reader based upon a reasonable expectation of the intention of the author or notional author. The inference must take into account matters of context and purpose that derive from within as well as out with the instrument. One very important aspect of context relevant to whether the implication was intended will be the nature of the instrument. As Justice Dixon once explained, the notion expounded by some since the engineer's case, that, I quote, in interpreting the Constitution no implications can be made, would defeat the intention of any instrument, but of all instruments a written constitution seems the last to which it could be applied. Only one qualification needs to be added. That qualification is that the further the implication departs from the words of the instrument, the more reasonably necessary it must be that the implication was intended by the notional author. Thank you.
I thank Justice Edelman for that very engaging and thought-provoking discussion. My mind is spinning with thinking of how one might deploy some of those ideas. I'll speak to His Honour a bit later about where it might be possible to get a copy of the paper for those who think about it a bit longer and more intensively. but I will try and deploy it now to ask you all in a moment. I'd like you to thank His Honour by conversely and raucously moving your hands by using cultural presuppositions as to signify, so whereby you will imply your gratitude, hopefully in a way in which His Honour will infer an appropriate amount of gratitude. That concludes this evening. People in the public law section of the bar will be in touch about further presentations in the course of the year, and whether or not in these COVID times we're brave enough to try for an annual dinner or not, but obviously there isn't one tonight, but there may be one later in the year. Thank you, everybody.